So welcome back to the Kelvin Show. Today we'll be talking about something serious. So Malaysia is currently facing a significant increment in sexual harassment as assault cases involving male victims, recording a 64% surge in cases from 82 cases in 2021 to 135 last year. And this has led to a call on the government to reassess the legal perspective on sexual offences against men in Malaysia. So today, we'll be having 3 guest speakers to talk about the issue of male rape in Malaysia. So without further ado, please welcome our first guest speaker, Ms. Lim Zisian, from the partner of Lim Zisian Partnership to share her thought on it. So Ms. Lim, please tell me, can a man be raped in Malaysia?
Thank you, Kelvin, for having me on the show today to discuss this critical issue. As a legal practitioner, I need to address a troubling reality in our Malaysian legal system. Currently, rape is defined under Section 375 of the Penal Code as a man having sexual intercourse with a woman against her will or without her consent. This definition is inherently gendered. Legally, only males can be perpetrators, and only females can be victims of rape. While punishment is up to 20 years with whipping, this creates fundamentally inequality where male sexual assault victims cannot be recognized as rape victims. So, how does the Malaysian law address male victims? So, when a male victim reports a case, it is to be investigated under Section 370(c) for carnal intercourse against the order of nature without consent. This carries up to 20 years imprisonment and also whipping. Now, the Anwar Ibrahim case highlights this distinction because he was charged under Section 370(b) rather than Section 370(c) for sodomy. So, under this case, the Attorney General explained our penal code has 2 sodomy provisions. Firstly, it is Section 370(b), where consent is, while on the other hand, it is Section 370(c), for non-consensual acts, where consent is, which means that crucially, Section 370(c) has a minimum 5-year sentence, while Section 370(b) has no minimum, thus making 370(c) the serious charge for non-consent situations like male rape. However, this creates significant problems, because male sexual assault isn't classified as rape, but falls under laws originally designed to criminalize consensual same-sex activity. Now, this carries additional stigma and fails to address sexual violence against men separately. And to note on, for victims under 18, the Sexual Offence Against Children Act 2017 provides enhanced procedures but still refuses to classify these as rape, thus maintaining that only women can be rape victims regardless of age. What we're seeing here is Malaysia's current legal system demonstrating a deliberate exclusion of male victims from rape recognition, which is a fundamental denial of justice, dignity of male survivors in sexual violence.
Thank you, Ms. Lim, for your valuable insights. As we all know, Malaysia is still taking a restrictive approach in determining rape. So let's now compare the Malaysian legal framework with the UK legal framework. And let's pass it to Professor Angelica Shi from Kuching University to share us her perspective from the UK legal framework.
Thank you so much for having me, Kelvin. So rape is defined in the UK under Section 1 of the Sexual Offences Act 2003. Now, this section states that a person, A, commits rape if he intentionally penetrates the vagina, anus, or mouth of another person, B, with his penis, where B does not consent to the penetration and A does not reasonably believe that B consents. This definition clearly sets out that person B, the victim of the rape, can either be a male or a female, demonstrating that the UK does recognize males as victims of penile rape. However, this was not always the case in the UK. Previously, the then existing Sexual Offences Act 1956 did not recognize males as rape victims. However, this was amended by the Criminal Justice and Public Order 1994 Act, which amended the SOA 1956 to include male victims. A landmark case that demonstrated this change was the conviction of Andrew Richards in 1995, who was convicted of attempted rape on another male under the SOA 1956 after its amendment. However, it is important to note that for male victims to be raped under Section 1 of the SOA 2003, they must be penetrated by a penis. Thus, this means that under Section 1's definition, only males can be perpetrators of rape and not females.
So, Professor Angelica, so how does the law then address the situation where the male victims aren't penetrated by a penis or where the perpetrator is a female?
Well, to address this, Section 2 of the SOA 2003, assault by penetration, was established. This section applies when person A intentionally penetrates the vagina or anus of person B with a part of their body or anything else. The penetration is sexual. There's no consent from B, and A does not reasonably believe that B consents. This section is completely gender neutral. It does not matter if the victim or the perpetrator is male or female. For sentencing, both sections 1 and 2 are indictable only offences and carry a maximum penalty of life imprisonment. To conclude, Section 1 and 2 of the Sexual Offences Act 2003 clearly establishes that men can be victims of rape and assault by penetration in the UK.
Thank you, Professor Angelica, for your scholarly input. So now we'll have a professional legal comparative analyst, Ms. Ong Lin Lee, to share her cross-jurisdictional analysis between the legal frameworks of Malaysia and of England and Wales.
Thank you so much for having me on your talk show, Kelvin. It really is a pleasure to be here. So in Malaysia, there are actually 0 cases of male rape reported, while in the UK, 9% of men say that they have been raped or assaulted by penetration, while 14% say that they have been pressured into sex, while 21% of men say that they have engaged in sexual activity with adults despite being underage. So going back to the 0 reported cases in Malaysia, that does not necessarily mean that male rape doesn't happen in Malaysia. It just means that Malaysia's law doesn't recognize male rape, because under our penal code, as mentioned just now, section 375, the definition just says that only a man can rape a woman. That's literally how it's defined. So comparing that to the UK Sexual Offences Act 2003, where it uses a more gender-neutral term, as what Professor Angelica had said just now. So it says that anybody could be a victim. It doesn't specify which gender, which protects male, female, or non-binary. So as we all know, Malaysia is a pretty conservative country, right? So because of this, there's a really big stigma. And we have always heard that boys don't cry, right? And therefore, it leads to boys cannot be raped. So this is what society has shaped us into thinking and all that. And because of this stigma, male victims would not have the courage to speak up because of this stigma existing. And this is actually true because according to an article from The Star, there's this boy who reported that he was being raped by his school warden and he decided to tell his parents. And his father in return beat him because his father thought that he was lying about the school warden raping him. So imagine being in the victim's shoes. And just recently in 29th May 2025, there was another case where a mom reported that her son has been groomed by his basketball coach. His basketball coach increased the trainings they had from 2 times a week to daily trainings, and then the mother got suspicious, found out through text messages, and filed a report to the police, and it just stopped there. The police did not do anything to further the investigation, and what's more infuriating is that the same basketball coach had been hired by another school. So this truly shows that Malaysian police doesn't really treat this as seriously. So if a man gets raped in Malaysia, he cannot rely on section 375. And because legally that's not really considered rape because he's a man. And so he can only rely on section 377C, which criminalizes carnal intercourse against the order of nature. So this is a really outdated way to say it, and it's really vague. It doesn't really reflect how serious of a crime this is. So that's really a big problem because in our federal constitution, Article 8, it says that there is no discrimination allowed. So how can this happen if the law won't even call male rape just because the victim is a man? So comparing to the UK, even though their law says that only a person with a penis, a man, can rape someone, but they do not specify the gender of the victim. So any gender could be a victim of rape. And the punishment, life imprisonment maximum in the UK, while in Malaysia 20 years maximum with whipping. So this really shows how the severity is. So life imprisonment and 20 years of jail plus whipping. So despite all this, in the UK obviously there's still some stigma, because in 2022 a police reported to the news that saying that there are estimated like 275,000 men of being sexually harassed, sexually assaulted, but only 1 in 5 of them actually stepped up and reported it. So this really shows how much of an issue this is. So, but at least in the UK, there are support systems like Survivors UK, Male Survivors Partnership that help men who've been through this. So the fact that these organizations exist shows that male survivors are being heard, recognized, and supported. So rape is rape. Malaysia really has to do some reforms regarding this area of law so that we can protect everybody and uphold our federal constitution Article 8, where everybody is equal before the law.
Thank you, Ms. Ong, for your valuable insights and highlighting the underlying legal lacunas and unfortunate incidences resulting from the legal gap in Malaysia. So now we are pleased to invite you to a virtual session featuring our esteemed Professor of Law from Maldives University, Professor Sofian Ahmed Nahin, to share her critical evaluation to the law of rape in Malaysia.
Thank you, Calvin. Getting right into it, Malaysia's outdated legal definition of rape reinforces heteronormative norms and fails to reflect the realities of sexual violence in contemporary society. We must raise the question, does a law inherited from British colonial rule, originally designed to criminalize acts against the order of nature, really serve its purpose in protecting survivors of sexual violence? Section 377C, while used in cases of male sexual assault, fails to classify such acts as rape and carries with it the stigma of immorality. The provision frames male victims more as participants in taboo acts than as survivors of violent crime. The only difference in imposed penalties between consensual acts under 377A and non-consensual acts under 377C is a minimum 5-year jail sentence. How seriously do we take non-consensual sexual violence? This framework may deter male victims, especially those in the LGBTQ+ community, from coming forward for fear of being criminalized themselves. Furthermore, this framework undermines public trust in institutions. When laws fail to protect all citizens equally, people lose faith in the justice system. I'll be reflecting a bit more on barriers to justice for male victims in Malaysia. Male survivors of sexual assault often suffer severe psychological consequences, including post-traumatic stress disorder, depression, anxiety, and suicidal ideation. However, there are no male-specific rape crisis centers, shelters, or legal aid tailored to male victims. Studies estimate that support for male victims is more than 2 decades behind that for female victims, with far fewer resources. Academic and institutional focus remains overwhelmingly centered on female victimization, leaving a major gap in understanding adult male sexual victimization, also known as AMSV. As mentioned by my esteemed colleague, Ms. Ong, there are multiple cultural barriers to be addressed. Common beliefs that men cannot be raped, that they must be physically dominant, cannot be vulnerable, or that they always desire sex marginalizes male victims. Some see male rape, particularly by women, as implausible or humorous. This is a reinforcement of patriarchal values that suggest only women need protection. Additionally, male victims may fear being perceived as weak or homosexual, especially if assaulted by another male. This fear often leads to silence, shame, and social ostracism, leading to survivor isolation. Furthermore, involuntary erections or ejaculation during an assault are often misinterpreted as signs of consent. In reality, such responses are automatic and unrelated to consent or arousal. Lastly, conservative values and a lack of open dialogue about male sexual victimization further suppress reporting and awareness and perpetuates a culture of silence. We must also address how male victims often face inadequate or dismissive responses from law enforcement. Victims risk being mocked, disbelieved, or interrogated aggressively when reporting, especially if the perpetrator is female or the act does not conform to conventional notions of rape. All this to say, without reform and broader recognition of male victims, justice remains unattainable for men. Back to you in the studio, Calvin.
So, based on the legal findings and perspectives from our esteemed guest speakers, one amendment that could be made on Section 335 of the Penal Code is to extend the scope of legal protection to include male victims by wording the provision in a more gender-neutral approach in line with Section 1, Subsection 1 of the Sexual Offences Act 2003. So, for instance, including anal penetration, digital penetration, as well as forced fellatio under the definition of rape. And secondly, rape should be generalized and not to be taken as a gender-specific crime by altering the word of man, woman, her, him, himself, and herself to any person or another person. As a result, the definition of rape is extended to include the possibility of male being the victim of rape, allowing male to fall under the legal protection under Section 375. The amendment upholds the guarantees enshrined under Article 8 of the Federal Constitution by reinforcing the principle of equal protection under the law. It entitles both male and female of equal legal protection against non-consensual sexual intercourse by a clearer statutory delineation of offences among rape, carnal intercourse against the order of nature without consent under Section 377C. The significance of reclassification lies in the alignment of sentencing provisions, particularly the imposition of penalties under 376, which may extend the maximum penalty to 30 years of imprisonment in certain circumstances. And this guarantees equal protection of the law for all individuals, regardless of gender, within the framework of the criminal justice system. And as stated by Janet and Fernandez, rape is not merely a moral transgression, but a violent breach of an individual's bodily autonomy and dignity. Rape should therefore not be treated as a crime protecting on mere female chastity, but a protection of the fundamental violation of human rights. So I will pass it back to Professor Sophia to elaborate on a more balanced approach and international practice that could be adopted.
Thanks, Calvin. I'll be touching on a balanced approach to reform and some concerns against full gender neutrality, especially in terms of classifying females as perpetrators. Without addressing existing inequalities, gender-neutral laws without safeguards could be weaponized. Critics worry that if perpetrators can be of any gender, the system may be manipulated. For example, a male perpetrator could file a false counterclaim against a female victim, saying, "She raped me," a tactic that could be used to silence or discredit real survivors. In societies where victims already face stigma, this could further discourage reporting. Let's look at the statistical reality of gendered violence. Most sexual violence is committed by men, not just against women, but also against men, transgender, and non-binary individuals. Some argue that rape laws should reflect existing power dynamics, and that ignoring gender completely might erase the protections needed for those most at risk. We must raise the question of whether the legal system is as of yet ready to protect all groups equally. Some critics suggest a gender-sensitive approach. Maintain strong protections for women, acknowledging their historical and statistical vulnerability, and extend legal protection to male victims through additional or amended provisions, ensuring that reforms acknowledge the role of gender and power while striving to protect all victims from sexual violence. In terms of international practices to be adopted, we can train police officers and judges to handle cases involving male victims with sensitivity and professionalism, avoiding victim blaming in investigations or court proceedings. We can establish support services specifically for male survivors, including counseling and medical assistance. These services should be safe, confidential, and culturally competent. We can launch public awareness campaigns to dispel myths such as men cannot be raped, promote a deeper understanding of consent, trauma, and gender-based violence, and encourage survivors of all genders to seek help. Back to you, Calvin.
So thank you guys so much for tuning in for our talk show today. We hope it was an educational and insightful session. And I'll see you guys in the next episode. Good night.